This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
But I beg to appear petitioner. I've been led by Mr. Bhattacharya.
May it please your ladyship, my lord. But on the previous 5 occasions, my lord, adjournment has been sought for. The ground of my lord.
And you went on counting?
I have the orders, my lord, now.
I have the orders here also.
My lord, I had placed my case. In fact, your ladyship had passed an order recording an undertaking which was given by the honorable speaker. The order is at page 16.
Yes.
Paragraphs 5 and 6 will be relevant. 5 to 9 basically. I'll place the entire order, my lord. Instant writ petition has been filed by the petitioner number 1, who is a member of the West Bengal Legislative Assembly and the leader of the opposition, and the petitioner number 2, who is also the member of the Legislative Assembly and the chief whip of the
What is the problem? Paragraph number 7.
Yes, kindly takes note, your ladyship. Now, the Secretary Para 6, West Bengal Legislative Assembly, has mentioned that entry of, this is, my lord, response to the query of the Honorable Court.
Yes.
The Honorable Speaker replies through, my lord, this memo of the Secretary.
Right.
The Secretary of the West Bengal Legislative Assembly has mentioned that the entry of the personal security of all members of the House, including ministers inside the Assembly House precincts, is prohibited, and it has been published in the Bulletin Part 2 from time to time for information of all members. Aforesaid bulletins are applicable equally in respect of all members of the Legislative Assembly. As the Secretary of the Assembly has intimated the Learned Advocate General that the security arrangement is maintained equally for all members of the Legislative Assembly, irrespective of their political affiliation, accordingly, the court is not inclined to proceed with the writ petition any further. Though the issue of maintainability of the petition was thought to be urged by the Learned Advocate General, but the court has not decided the issue. The instant writ petition stands disposed of, with the observation that all members of the Legislative Assembly shall be treated equally. My lord, we communicate this order, my lord, the solemn order, the next page, on the 29th of August. We serve it upon, my lord, the Secretary of the Assembly, the Director General of Police, the Commissioner of Police, Kolkata, and, my lord, the Director of Security. We indicate that attached, please find herewith a copy of the order dated such and such, passed by Her Ladyship, the Honorable Justice Amrita Sinha, in the aforementioned matter.
Page 20, there is a notice.
Now, on the basis thereof,
30th of
yes,
August.
30th of August, they hang up this notice, my lord. This is nothing but a moonshine I have pleaded in the petition. They say that no one will be permitted to enter with their security. Now, your ladyship kindly takes paragraph number 5 and 6 of the contempt application. At page 9, in willful and deliberate violation of the solemn judgment and order dated 28/8/2025, on 4/9/2025, the Honorable Chief Minister of West Bengal was permitted to enter the precincts of West Bengal Legislative Assembly accompanied by her full security detail. At the same time, the security personnel attached to the MLAs of the opposition were denied entry into the assembly premises on the basis of a notice dated 30/8/2025 affixed on the gates of the assembly precincts, stating that personal security of honorable ministers and members are prohibited from entering the assembly precincts. It is stated that despite such notice dated 30th of August 2025 being affixed, the same was a moonshine in as much as the Honorable Chief Minister of West Bengal, who happens to be a member of the Legislative Assembly, entered inside the Legislative Assembly precincts, as well as the Assembly building with her full security detail. Video footages, my lord, we have annexed along with, my lord, the necessary...
Tell me, apart from the Chief Minister, is any other minister getting this benefit?
My lord, it happened on that particular day. We immediately, my lord, brought it to the notice of the Honorable Court, my lord, by way of filing the application, my lord. So whether, my lord, thereafter, my lord, any benefit has been given or not, my lord,
not thereafter, even on that day.
So that day, my lord, there has been a violation insofar as, my lord, all MLAs, because it was ordained that all MLAs, all members of the Legislative Assembly, para 9,
yes,
has to be treated equally.
Right. Apart from the Chief Minister, is there violation complained of against any others?
On that day? On that day, it was the MLA from Bhawanipur Assembly constituency, who
Yes.
happens to be the Chief Minister,
Right.
who was permitted to enter the Assembly.
That apart, you do not mentioned.
No, it is not there in the
anybody's.
petition, my lord. I cannot travel beyond the petition, my
Right.
lord.
So apart from that, you
Yes.
do not.
So this is an act of contempt, my lord. I say, my lord, this has been done, but the undertaking was furnished with an intent to mislead the honorable court to pass an order which, my lord, since furnishing of the undertaking was within the knowledge of the contemners that they will be violating.
No, but then a notice has also been put up,
This
and there
notice,
is no exception.
no, this notice was used as against, my lord, the MLAs of the, to deter, my lord, the applicants who have brought it to the notice of your ladyship, my lord, the act of contempt. On one hand, they say that there is a notice. On the other hand, they say that this notice, for some reason, is not applicable in respect of one of the particular member of Legislative Assembly. My lord, I will be, my lord, referring to three decisions, my lord, because, my lord, the conduct, why I said 5 times it has been adjourned, my lord, adjournment has been sought for, but this conduct itself is demonstrative of, my lord, the lack of solicitude that the contemners have, my lord, towards the dignity and majesty of the honorable court. First of all, my lord, a wrong undertaking, my lord, has been furnished to the honorable court.
All right, I followed.
Yes.
Yes, then.
So, my lord, I was relying upon. Chapter yes. But the 16. Kindly bear with me for a yes. My lord, first is, my lord, 2020, volume 17, Supreme Court cases, page 528. The relevant paragraphs, my lord, that I will be relying upon. But are, my lord, paragraph number 23 to 25 and para 31.2. 23, my lord, quotes Lord Diplock. It says that it is justice itself that is flouted by contempt of court, not the individual court or judge who is attempting to administer it. It is also important to remember that while considering the question of disobedience of an order, what must be regarded is the letter and spirit of the order together with the bona fide or genuine belief of the alleged contemner as to such order. Now, thereafter, my lord, Rosnan Sam Boyce has been quoted, my lord. I'll be reading, my lord, from the para 9, my lord. 25 has quoted para 9 of this judgment. We are, of course, quite conscious of the fact that the proceedings in the contempt are quasi-criminal in nature, that the law of contempt has to be strictly interpreted, and that the requirements of that law must be strictly complied with before any person can be committed for contempt. However, as we have pointed out, respondent number 1 gave an undertaking based on an implication or assumption which was false to its knowledge and to the knowledge of the respondent number 2. Respondent number 2 was equally instrumental in giving of this undertaking. This implication or assumption was made explicit by the clarification given by the learned counsel for the respondent number 1 as set out earlier. Respondent number 2 was equally responsible for instructing counsel to give this clarification which was false to the knowledge of the both. Both respondent number 1 and 2 have tried to deceive the court and the appellant. In view of this, we fail to see as to how it can be said that they are not guilty of contempt. But this, whether they are guilty or not, my lord, that will come at a subsequent stage. I am, my lord, at the stage of issuance of rule, my lord. Now, my lord, para 31.2, my lord, it refers to Ashok Paper Kamgar Union's case. Section 2B of the Contempt of Courts Act defines civil contempt, and it means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of undertaking given to a court. Willful means an act or omission which is done voluntarily and intentionally, and with the specific intent to do something the law forbids, or with the specific intent to fail to do something the law requires to be done. That is to say, with bad purpose, either to disobey or to disregard the law. It signifies a deliberate action done with evil intent or with a bad motive or purpose. Therefore, in order to constitute contempt, the order of the court must be of such a nature which is capable of execution by the person charged in normal circumstances. It should not require any extraordinary effort, nor should be dependent either wholly or in part upon any act or omission of a third party for its compliance. So, my lord, these are the paragraphs I am referring to, my lord. I have already demonstrated, my lord, the solemn order, my lord, was duly communicated not only, my lord, to the parties, my lord, but also, my lord, to the persons in charge of security. Despite that, my lord, and despite a categoric observation recording the undertaking given by the Honorable Speaker through the Secretary of the Assembly, and, my lord, the observation made at para 9 of the solemn judgment and order, there has been a willful and deliberate violation, my lord, by the contemners, my lord. But the other judgment, my lord, I did not cite it right now. It states that willful breach of an undertaking, my lord, that
Alright.
constitutes contempt. But till date, my lord, they have not even come forward with an affidavit to explain their conduct. So, my lord, if it is presumed that they do not intend to file any affidavit, my lord, may kindly hear it out, my lord, and hauls them up, my lord, for contempt. Because apology, my lord, it has to be tendered at the first instance. The conduct itself shows, my lord, how obdurate their conduct is.
All right, let me hear.
Yes. But একটা judgment শুধু দেখি দাও।
দেখি দাও
But only another one more, my lord, decision that I'll be citing, my lord. Reported in AIR 69 Calcutta, page 1. No. I'm just referring to para 12, 13 and 14, my lord. Speaks about the conduct of the contemner and the stage at which, my lord, apology should be tendered. Para 12, 13 and 14, my lord. এটা তো 76 2 Supreme Court.
Very well.
Yes. And, my lord, regarding undertaking, my lord, I'll just, my lord, cite one part of a paragraph which states that an undertaking given to the court by a person or corporation in a pending proceedings, well, this is reported in AI 1976 volume 2 Supreme Court cases, page 951, basically para 2 to 6, but I'll be referring to para 5 only. Para 5, the quoted portion which starts from where, however, there is an express direction or undertaking in the body of the order, a breach will enable an immediate application for committal to be made.
Paragraph 5.
Paragraph 5, my lord, it's, I'll place the entire paragraph, my lord. Before parting with this case, we may refer to Halsbury laws of England, where after citing Dashwood versus Dashwood for the proposition that when a party fails to comply merely with the terms of consent order, the remedy of the injured party is to apply not for committal, but for an order for specific performance or an injunction, and then to base proceedings for contempt on any subsequent breach. The observation is made where, however, there is an express direction on undertaking in the body of the order, a breach will enable an immediate application for committal to be made. In the same volume at page 44, para 75, we find the law thus stated, an undertaking given to the court by a person or corporation in pending proceedings, on faith of which the court sanctions a particular course of action or inaction, has the same force as an injunction made by the court, and a breach of the undertaking is misconduct amounting to contempt. The case before us being a case of a deliberate violation of an undertaking to the court, the effect was the same as that of a breach of an injunction. So, my lord, these are my humble submissions, my lord, but I was praying for issuance of rule, my lord. Till now, my lord, they have not even responded, my lord. And on the contrary, they have been served, my lord, and they have appeared on the 12th of November.
All right.
Grateful to your ladyship.
The matter, my lord, was adjourned, my lord, on 2 or 3 occasions at my instance. Because, my lord, I intended to argue, my lord, the maintainability of the contempt application on the ground that, my lord, there is no decision. Now, if your lordship may kindly have a look to, my lord, the order of which, my lord, violation has been alleged, where it's at page 16 of the contempt application. First paragraph says, why the writ petition? Second is, my lord, second paragraph is quashing of notification restricting the entry of central security forces into the assembly house precincts along with their protectees. Then para 3, submissions made. Para 4 is, my lord, I have commenced argument, but on the direction of the court, the learned Advocate General has obtained instructions from the speaker with regard to the applicability of the notification. The query of the court has been replied to by the speaker through the Secretary of the Assembly, communicated to the Advocate General. The same has been retained with the records, copy handed over to the counsel of the petitioners. The Secretary has mentioned that the entry of the security personnel of all members of the House, including ministers, inside the Assembly precincts is prohibited as it is published in the Bulletin Part 2 from time to time for information of the members. The aforesaid bulletins are applicable equally in respect of all the members of the Legislative Assembly. As the Secretary of the Assembly has intimated the Advocate General that the security arrangement is maintained equally for all members of the Legislative Assembly, irrespective of their political affiliation, accordingly, the court is not inclined to proceed with the writ petition any further. Then, para 8 is very important for me. Though the issue of maintainability of the writ petition was sought to be urged by the Advocate General, but the court has not decided the issue. So the writ is disposed with the observation that the Legislative Assembly shall, that the members of the Legislative Assembly shall be treated equally. My dear Lordship was pleased to, my lord, put a very pertinent question to my learned friend as to whether, my lord, the ministers of the ruling party, whether they are being allowed to go with their security or not. My learned friend chose not to answer. And, my lord, the paragraph 5 is very craftily drafted. All credit goes to Mr. Bhattacharya possibly. Now, please take paragraph number 5. In willful and deliberate violation of the order, the Honorable Chief Minister of West Bengal was permitted to enter the precincts of the Assembly, accompanied by her full security detail. At the same time, the security personnel attached to the MLAs of the opposition were denied entry into the Assembly premises on the basis of the notice dated so and so, where there is no pleading that, my lord, the Treasury bench members were allowed to enter the premises with their full security. Please take note another paragraph, the acts of contempt at paragraph 7. 7A, kindly have a look. These are the acts of contempt. Permitting the Honorable Chief Minister to enter the precincts of the Assembly accompanied by a full security, while the security personnel of the MLAs of the opposition were denied entry. Doesn't say that the others were given, ruling party members were allowed, but oppositions were not allowed. Then B is willful and deliberate violation so and so by restricting the entry of the security personnel attached to the members of the Legislative Assembly of the opposition, thereby not treating the members of the Legislative Assembly equally. Again, doesn't say that the other members of the ruling dispensation were allowed. So, my lord, these, my lord, my first respectful submission is, my lord, unless, my lord, there is a decision, my lord, there is no contempt. My lord, this has been, my lord, decided by the Honorable Supreme Court. And more particularly, my dear Lordship was pleased to record that the maintainability of the writ petition also was itself in question. But your Lordship felt that why go into all this?
I still feel that there is no requirement of going into all these things.
Yes.
Even at the contempt stage.
Right. Right.
And that was the query as to whether the notice that is annexed to the contempt
Right.
application at page
Yes,
20,
20, yes.
whether this is being applied equally in respect of everybody.
Everybody except the Chief Minister.
Why this exception?
Yes. Now, my lord, this exception, my lord, some exception has to be made.
Why? What
Yes.
is the
My lord,
requirement?
here, my lord, my lord,
Because
but since my lord, I am not in the
most
read. Yes,
protected area
yes, yes.
with so many legislators over there. Why will one of them feel so insecure to carry the security personnel
No,
there?
it
Because
is not, it is the Speaker, my lord, who has allowed the Chief Minister to enter with her full security.
is
Yes.
it a requirement, or is it just a show that yes, I'm going there with
Yes,
so many?
but that is what, my lord, I intended to argue, my lord, at the writ stage, whether, my lord, this is something which can come within the arena of judicial review.
The court from the very first day, I say I am not
Right.
inclined to go into this.
Please, that is my submission. But let the security in the assembly be looked after by the presiding officer of the assembly. Here, my lord, if I am to address your lordship, my lord, on the difference between the chief minister and the other members, my lord, I have those judgments.
Not the difference.
Yes,
This is only security arrangement.
yes,
If the security arrangement is all right, then there is no
yes.
requirement.
Well,
Unnecessary, see, the court's time is being wasted
right.
hearing all these things.
Yes, but I would be suggesting that it is best left to the speaker or this presiding officer who is, my lord, entrusted to look into all these aspects.
And it is you who have to guide the speaker as to how he is to act.
Me.
Yes, the AG. See, these things crop up.
My lord, I cannot say a lot of things which I want to say.
Whatever is required to be submitted in court,
Yes.
you are within your limitations. The court has
Yes.
its own limitations, and let those persons also act.
But could I say this, my lord? Since
Don't say if you
no. Since my lord is pleased to make an observation, my lord, there are, my lord, 4 constitutional authorities over here. The judge, your lordship is referring to me, the AG, the chief minister, and the speaker. 4 constitutional authorities.
and you will be advising 2 of them.
Yes. But all these, at the instance of a person who thinks that he is a constitutional authority, but he is not a constitutional authority.
Maybe
Therefore, my lord, the purpose is,
the person's thinking.
yes, the purpose is, as has rightly fallen from the court, that one constitutional authority should have, my lord, trust and faith on another constitutional authority. Therefore, my lord, I very respectfully and humbly, with, my lord, utmost deference to, my lord, the judiciary, I am submitting, my lord, that leave it to, my lord, the speaker. Let him undertake the activities to which, my lord, he has been entrusted with. Well, please drop the contempt proceeding. Well, otherwise, my lord, I have to go on arguing that whether there is a list decided.
Judgments are coming for this.
No. I have not placed my
You
judgment.
have not placed.
Yes.
The petitioner has placed.
Yes.
You will come up.
Yes.
The court has to adjudicate.
Right.
If the court did not adjudicate the writ proceeding, and if the contempt is to be adjudicated,
Exactly.
then
Exactly. This is what my submission is. Well, kindly drop the contempt proceeding. If my learned friend wants to appoint to be decided, let that be decided first. Whether at all a writ could have been maintained on this. And your lordship was very kind enough to record that. The maintainability was raised. Your lordship felt that it's not required. We are not required to go into this. I would be very humbly submitting, but I don't know why is this proceeding being dragged. But I have my remedies open. But I have not chosen to do that because I did not expect that these kinds of, my lord, what should I say, my lord, the other, my lord, interest in the matter will surface in before the judiciary.
please come. The petitioner presses the contempt application. Stop. The learned Advocate General presses the contempt application and concludes argument. Stop. The learned Advocate General commences argument. Stop. Prior to hearing the contempt application any further, the court is of the opinion that the notice annexed at page 20 of the contempt application be applied equally in respect of all the members of the Legislative Assembly. Stop. Hearing of the contempt application stands adjourned till 27th of April 2026.
Great.
My lord, may kindly, your leadership may kindly clarify, my lord, all means includes the chief minister, because here, my lord, there is a sufficient.
Mentioned all.
No, that is already mentioned, my lord, in para 9.
Yes.
Despite that, my lord, the learned Advocate General has, my lord, categorically admitted that it is applicable as against all but the chief minister, who also happens to be an MLA. My lord, I was just, my lord, praying for, my lord, that limited observation, my lord.
I'm grateful.
Very good. I'm sure, my lord, since, my lord, the learned Advocate General is here.
Yes.
So the constitutional authority will be advising, my lord, the
Right.
constitutional authority to act constitutionally.
Somebody who is not a constitutional authority should not
I'm a litigant. I'm an
think
authoritative
himself to be a
person.
constitutional authority
I'm availing my rights under Article 226
and trying to apply Article 40.
No, yes, Article 14, absolutely.
Sure. Item 2.
Grateful, great.
I'm grateful.